oversight the police in regards to the functions of the police that are anchored in Article 244. So the mandate of IPOA is to oversight the police in performance of their functions, to support the police in ensuring that they comply with human rights standards, discipline, and of course, if there is offenses that are committed, to investigate those offenses, to monitor their operations, to just ensure they do their work within the parameters of Article 244, to inspect.
Okay, in a nutshell, we can say
so, in a nutshell, we can say the work of IPOA is to oversight the police in the performance of their functions, to investigate any criminal acts, to monitor, and to inspect.
Okay, okay. So generally out here, the feeling amongst Kenyans, you see, an institution is said to perform depending on the effectiveness or impact of their service on the ground. So there's a feeling generally amongst Kenyans that IPOA was doing quite well and could really be felt, the services could really be felt at the beginning. But somewhere down the road, it went down. Now, I just want to give you an opportunity to highlight for us your achievements. I've gone through your CV, and I don't know if I'm the one who's looking at it in a narrow way, but I get the feeling where the rubber meets the road in terms of the IPOA mandate, there isn't much you've covered in your CV. I see here you are talking about developing a HR instrument, which is good and commendable.
That is for the entity, for internal, yes, not in regards to the police. In terms of the police, a lot was achieved. And allow me to mention, before Honorable AG became AG, she was in DPP. She was in the office of DPP, and we worked very closely together. One of the areas we were able to deal with is address the issue of backlog of cases. And we were able to reduce the backlog of cases from over 20,000. By the time I was leaving, we had closed over 12,000 cases, up from about 3,000. The matters before courts, when we joined, there were hardly 60. I left over 470 cases before courts. Some of the outstanding matters, like the Baby Pendo case, working very closely with the office of DPP, we were able to close on that matter and make progress. So we were able to do quite a lot in terms of pushing, because justice delayed is justice denied. Basically clearing the backlog, ensuring that matters are closed within a short time, because even if you're not being prosecuted, you need to know that you've been exonerated so that we don't keep the file. So we're able to deal with the issue of backlog. In terms of supporting the police with reforms, the recommendation on armored vehicles is a recommendation of IPOA. The recommendation on housing is a recommendation of IPOA, and it has been implemented. The recommendation on authority to incur expenditure for OCSs, so that the OCSs can have the money to fuel the cars and to do the little things they need to do within the police station, is a recommendation of IPOA.
I'm assuming all this you're telling us is under your leadership.
Yes, yeah, those were implemented. They were implemented under my leadership. Some of them started with the first IPOA board, but the first board had a lot of challenges setting up. So a lot of things were left unfinished. So we came finished and oversaw the implementation. So I'm talking of those that were implemented while I was there. Okay,
the reason I'm asking is because you have a segment in your CV where you're talking about your achievements in IPOA, and none of that is captured here. So I'm just curious as to why you've done quite a bit from what you're presenting here, but why none of it is reported anywhere or captured even in your CV?
In my CV, I focused on my role as the chair for the institution. So what I did for the institution, among many other things, and also develop the regulations
Okay.
that were long outstanding.
Okay, the other thing I wanted to engage you on this morning, as you are aware, under Article 159 sub-Article 2C, as an institution, we are called upon to promote ADR. And as an institution, we have what we call court-annexed mediation, basically a platform for mediators to work in partnership with courts to resolve cases. So there's a conversation that is very live currently amongst the legal practitioners. And since you are one, maybe you can share with us what that conversation is about in the area of court-annexed mediation.
Personally, I've not been shortlisted as a court-annexed mediator.
No, I'm not saying you're applying for. You see, we are examining you in very many areas.
Yes.
Okay, one of them is just to understand what your mandate is. The question of ADR is part of your mandate and your concern.
Yes.
If you're a Supreme Court judge. That's
Yes.
why I'm asking you this.
The issue of ADR, for me, I think it's an important area. Because even without going through the ADR per se, the way, court-annexed mediator, we are always filing consent judgments, which is a way of, ADR.
There isn't much time. Let's just go back to the conversation that is live amongst legal practitioners on court-annexed mediation. You mentioned earlier that you do mediation, isn't it? In your introductory statement. So that's why I'm asking you this. What is the live conversation right now? Okay.
That
you are able to remember? No. I can give it to you. So the discussion is around non-legal practitioners practicing as mediators.
okay.
And I was just going through the streets of social media last night, and I want to read you a quote from one of the legal practitioners. He'll remain anonymous for purposes of our conversation. In the matter of court-annexed mediation, I refuse to appear before a mediator who is a layman to adjudicate a legal dispute in which I'm my client's last hope. What is your take on that statement?
Now I understand. The use of non-legal mediators, because mediation, unlike arbitration, is not meant to be legally complicated. It's one of the ways of ensuring that parties get an opportunity to access justice in an environment that does not make them feel limited. And that's why when you look at mediation, the key area that you look at is what are the underlying issues. You need to resolve the underlying issues, because many times the issues that bring people to court can actually be resolved if you identify the underlying issues. In legal practice, you deal with what are the legal issues here. What does the law say? You don't give parties an opportunity to bring those other issues that may not be legal but are important for them to be resolved so that you retain relationships. Because legal way is adversarial. So I think there is a place for mediation, and there is a place for people who are not legally, because the way you do the agreement is structured. You don't just go and do your agreement out there. Is guided so that it captures the issues in a way that can help the court arrive at a well-reasoned decision ultimately. So I think there is a place for mediators, because they are not supposed to be legalistic or legalists. They are supposed to help the parties resolve their issues in an environment that enables to do that and retain relationships. Yes.
So I take it from your answer is your take is that it's not really a valid concern.
It's probably a concern that is arising out of failure to understand the role of mediation.
Thank you.
Probably those who are complaining are not mediators, and it's high time they trained as mediators to understand the role of mediation.
Thank you. Thank you, my lady.
Thank you, and sorry for that. Thank you, Chair. Good morning once again, Council.
Good morning, Madam Caroline.
Now, if you were to identify any three significant challenges currently facing the Supreme Court of Kenya as an institution, what would they be, and what role would you play in addressing those challenges?
I believe one of the challenges that the court could be facing, just like many other government entities, is the challenge of adequate funding. And adequate funding affects access to justice. The Supreme Court is based here in Nairobi and has only two other sub-registries in Kisumu and Mombasa. I want to believe an ideal situation would be where it can get closer to the parties that may want to access its services, but to do that, it would require resources. The other challenge is, I think the Supreme Court has been misunderstood. I was looking at the report on the annual conference that it held to call for papers for people to come and say what the issues they have, because people have complained that even some of the decisions seem not to agree. This decision says this, and this decision says this, and Supreme Court has to keep on clarifying. So I think the other challenge probably is facing being the apex court and not being too old is the challenge of being well understood, including by lawyers. The other challenge could be that challenge of being seen as political, putting it in a very difficult situation where you have to balance accountability and independence, and make people believe that the decisions you make are not driven by other extrinsic consideration, especially on the political arena, where people want to decide the way from their lenses, and you all have different lenses. So it's still charting new waters, and I believe even as they continue to grow new jurisprudence, there is a place to somehow go out there and help people understand it.
Okay.
Of course, that would take resources again, but yeah.
Okay. While at IPOA, please tell us of a time you were faced with an ethical dilemma and how you went about it, and perhaps any lessons you learned from the experience.
I can say there are many issues, but let me focus on an internal one. The internal one was, at one point the commissioners wanted to get rid of the CEO. And as the chair, other than being a lawyer, as it has been noted by Honorable Mwanza and probably the rest of you, I'm also HR. So I could see the commissioners are making a grave mistake. Because this is an administrative action under Article 47, you do not only look at the procedures, you look at the substantive aspects of the issue. And I felt that termination, when you look at it, procedurally may have looked okay, give notice, ask the CEO to explain, but substantively, we're making a mistake. So I stood my ground. It was difficult, but to resolve it, what we did was to seek the opinion of the Attorney General. It looked like I was fighting a lone battle at some point. And I told them before we make a mistake that could hold us accountable as individuals, and we are surcharged. If we lose this case, let's get the opinion of the Attorney General. And we were well guided, and we complied with that opinion. It was a really difficult period for two reasons. One, I looked like I was alone. Two, it was the formative stage where we needed to bond and enable ourselves to understand each other so that we can run the entity as one body of commissioners. So it was a very trying moment. You are new, and you need cohesion within your team, and it looked like that cohesion is drifting through your fingers, and you want to hold it. Yeah.
Any lessons learned?
Yes. It's always good when you're in doubt to seek an opinion. The Office of the AG, for example, exists to do that. But it also taught us thereafter to bond and understand one another so that the relationship don't have to go drift that far. We can discuss most of them in a more amiable manner.
Okay.
Yes.
All right. Finally, for me, I'm looking at the feedback we received from the public. As part of this recruitment process, we engage the public to get their views on the candidates that we are taking through the process. And there is a number of positive things they've said about you, but I will highlight three that I would like to get your views on. There are people who felt that you're domineering, and they said that you do not give a chance to consensus. They also picked your close political leanings, and they said this may hamper your role as a judge. And then others, and I guess these are from IPOA, said that while you were serving as chair IPOA, during recruitments, there were some irregularities, and they felt that you would forward names given by top political offices. And then this would mean that the ones that do not have godfathers did not have a chance at IPOA. Maybe you will tell us what you think about those comments from the public. And with this, maybe how you tell us how you'll maintain judicial impartiality when a legal question is before you and that has profound political implications.
Thank you. The first issue is the issue of domineering. It's wrong to do your own self-assessment, but I don't think I'm domineering. I'm probably firm. And there are a lot of people we've worked with here. We worked with ODPP, we worked very closely with public service. They would be able to tell really whether I'm domineering. But I know I'm firm because as a chair of an institution, if you fumble and you're not firm, a lot of things can go wrong. Running government entities is not a walk in the park. There are many areas you need to look at. And I believe even the issue of domineering could be coming from IPOA because there are areas you don't see consensus. Areas of accountability. It's either you are accountable or you are not. Areas of prudent use of public resources. It's either you are accountable or not. And when you are leading an institution, you get into conflict with a lot of people, and if you put your foot down, you say you are domineering because you are not accommodating certain things. But I do not think I am, because if I was, I would not be able to establish the very good working relationship that I established, a lot of support that I got from other agencies to make the work of IPOA possible. And as a judge, you need the independence of mind, even when you work in collegiality with others. It's good sometimes to know what you're talking about and to have your facts right. Then, as you meet as a college of judges, you can look at each other and see how you make progress, but that does not, collegiality doesn't mean you don't have independence of mind. or intellectual discipline, it's expected you should have that. Close political leanings, again, I would say no. I was heading an institution, it's a government entity, you work within government policy. Even when you're oversighting, you don't go outside of the government policy. And therefore, it's important that whatever you do be in line with the government agenda. And whether that is considered to be political leaning, I do not think so, because I did not participate in things that showed I was favoring one political side more than the other, or one political, not an active politician. But when you're serving government, you have to work within the government policy. And there are not too many ways about it. You can be doing your things and you're a government official. And every government has its agenda. You have to work within that agenda of the government. In terms of recruitments, I do not think there were any irregularities. The recruitment processes were open. They are subject to audit. The Auditor General audited those processes. We never got complaints on recruitments. Nobody came to audit and ask questions. And we did them openly. The documents are there for anybody who would want to audit. So I would want, if there were any irregularities, certainly, why wouldn't anybody then ask for an audit or the process to be audited to clarify? It's an open process, it's a government entity. Everything is in black and white. Yes, that would be my response to those issues. And even if you don't want to go to any other entity, go to EACC, let EACC come in, or CAJ to come and audit those issues, and they are open, and we can be guided. I think IPOA had a very, very well regional representation. It's a highly technical area where even in recruitments, you've got to be very careful with the kind of technical capabilities that you bring on board. And therefore, I never received any complaint while there. I've not received any that has followed me after leaving. I would want to believe that we worked within the parameters of our mandate.
Okay, fair enough. In the interest of time, maybe the last bit of the question on how you will maintain your judicial impartiality, especially when a legal question is before you and it has profound political implications.
Judiciary, especially at the Supreme Court, you are guided by the Constitution and the law. And therefore, whatever you do must be supported by the Constitution and the law. If peradventure I had any issue where I feel conflicted, I would let the other members of the court know and discuss it openly and decide the best approach to it. If after disclosing what I think is my fear, it's felt that I need to continue, then it's incumbent on my colleagues to ensure that whatever we do, they are conscious that I declared something. Otherwise, I would be guided by the Constitution, the law. I'm a very committed person to protecting the constitutional safeguards because I've worked in the space of human rights. I would want to see the values in Article 10, equality, equity, most of strong believer of devolution, being enforced. So I would strictly be guided by the law and the Constitution.
Thank you, and I wish you well. Thank you, Chair.
Thank you, Honorable Chair, and welcome again, Wakili Ann.
Thank you, Commissioner.
Good to see you again.
Good to see you too.
Now, in your introductory remarks, I heard you say that you are strong in governance, and that is what you will be bringing also to the basket in the judiciary. The judiciary plays a crucial role in promoting good governance and accountability among public institutions. Assuming you are a judge handling a case involving allegations that a senior government official violated constitutional principles of transparency, accountability, and public participation, how should you approach such a matter to ensure that justice is served while maintaining the balance between the judiciary and other arms of government?
Thank you. Certainly there is a need for separation of powers, but judiciary sits at a place where it has been given the responsibility of advising government entities. So if the matter then, most institutions have their own mechanisms of dealing with these issues, but if an issue came and it requires interpretation of maybe Chapter 6, then the Supreme Court, I would use my expertise in ensuring that we give that interpretation, that guidance, while ensuring that the independence of these democratic institutions is not unnecessarily interfered with. It's a thin balance, and that's why I have absolute respect for judiciary, because they have to ensure resolution of disputes by guiding on what the law says, while ensuring that the democratic institutions are able to practice their mandate. So I would use that expertise to give that guidance, fully aware of the mandate of the institutions.
Now, my second question, the judiciary often faces challenges such as backlog, corruption allegations, either perceived or real, and delays in delivering of justice. Could you tell us, as a Supreme Court judge, what leadership strategies you would propose or promote to strengthen governance within the judiciary and improve transparency, accountability to the public, and efficiency?
On the issue of backlog, I am aware that we have, through the NCAJ, active case management policy. I would, to the best of my ability, be guided by that. Would also try to enforce a non-adjournment policy, and if a matter has to be adjourned, then it has to be very well defended why it should be adjourned. So I would have a non-adjournment policy on those on matters, so that we can observe the timelines. That is at the Supreme Court. I know there are a lot of other initiatives that are being undertaken by judiciary. In terms of corruption, I think you've called it right. It's a perception. And to deal with that, again, I'm aware judiciary has done a lot to deal with that by ensuring internal processes are put in place, like employee protection units, and so on, implementing the guidelines that were developed by NCAJ. By the time I left, they had not been complete, but I'm happy to note now they are complete guidelines on anti-corruption. If it's matters that touch on an issue that touches either a judge or a judicial officer, then they should be fast-tracked. So in terms of governance, then I would support and be a champion of STAJ, and social transformation through access to justice is a 10-year plan that is implemented annually, and accountability reports are done every year through the State of Judiciary and Administration of Justice reports annually. So it's just to ensure that we continue informing the public, we continue being accountable, we continue actively ensuring that the access to justice interventions that need to enhance that are being implemented. And eventually, and holding, like what judiciary has started, dialogue. I'm also happy to note they now have a spokesperson who can answer to a lot of those allegations. Otherwise, profiling judges and judicial officers as corrupt, I think, with a lot of respect, should be resisted because it's a perception. But then we should not close our eyes to it. We need to take action to ensure that the concerns that the public has, because again, justice affects the citizenry, addressed by sharing information and ensuring we understood what we do as judiciary.
Okay, thank you. I wish you all the best.
Thank you.
Good morning again.
Honorable Governor,
Hope you're not tired.
I need the job. So I'm ready to convince you
Thank
that I'm
you.
the right person.
Thank you. Now, how would you approach stakeholder engagement without compromising the impartiality and while maintaining the independence of the judiciary?
Stakeholder engagement is a very critical aspect. And under judiciary, there is a mechanism for stakeholder engagement. Under the NCAJ brings together all justice sector players. And therefore, within that framework, you can engage almost all the stakeholders within the justice sector. Another way is when the Supreme Court was celebrating 12 years, they called out for people to write, and it's another way of stakeholder engagement without compromising on the accountability and the status of the court. So there are many aspects of stakeholder engagement. You can do lectures, dialogues, and you can engage specific stakeholders through entities like NCAJ that bring together both state and non-state actors, and you can reach a wide range of almost every sector that you want to reach within that framework. Mm-hmm. If it's parliament, again, there are ways of engaging with.
Okay. What role does the judiciary play in community development?
Judiciary plays a lot of roles in community development because ability to do businesses and, like we discussed earlier, even own property, access to justice drives community confidence. So the way, the speed with which the decisions are delivered, the accessibility, removing the complexities, ensuring issues that touch on commerce are speedily handled so that they don't hinder the economic well-being, the social aspects. And I'm aware that Article 43, judiciary has made some decisions in terms of ensuring that the socio and economic aspects of the communities are protected. So through STARG, social transformation through access to justice, removing technicalities, and ensuring justice is delivered speedily.
Okay, thank you. Wish you well. Thank you, Honorable CJ.
Thank you, Honorable Governor.
Thank you very much, Honorable Commissioners. Before you close, or before we close, you saw me going through your records, and
Yes.
we sent you a letter where we requested you also to provide us with your declaration of wealth. I don't see it here. What happened? You are a human resource practitioner. So I expected you to comply with the letter requesting you to supply us with the documents.
My apologies, Honorable CJ. I thought the ones I uploaded on the system are adequate. I have copies. I can supply them.
You have the letter inviting you for the interview?
The letter inviting me for the interview, I think it listed
It specifically asked you to bring the declaration of wealth for the last 3 years. I've looked through your documents. I didn't see it.
I have the documents at home and I had attached them to the online application, but I can deliver them.
They are not even online. I've looked online. I cannot see.
They may have dropped. I have them, Honorable CJ.
I'm just wondering why you didn't provide.
Probably it was an over. I assumed that the online ones came through and my apologies.
Okay.
My apologies.
Very
I
well.
can deliver them by close of day.
Very well. This brings us to...
Should I do that, Chair? And where do I deliver them?
I think we have just noted they are not here because we are finishing with you now, because you ought to have read your letter properly and complied. So I don't think there is any need to bring them after we are finished with you today.
Oh.
Yes. So what we are going to do is, before we close, we always also give a candidate an opportunity to address us.
Allow me, Honorable CJ and Chair, to take this opportunity to thank JSC for the opportunity. It's a privileged position. I feel honored. And I hope that I've persuaded the team well enough. Obviously, I'm finishing on an anticlimax, knowing that my documents did not come through because I honestly attached them to
They are
the
not
online.
even in your bundle.
I had copies are not there. I admit, and I looked at them and then I said, but I forwarded these things online. But they're available. I've done wealth declaration. I'm a public officer. I still serve, not really I still serve in the government at Moi University Council. And declaration is a requirement and I'm totally compliant. And therefore, I do hope that I'll be found to be the right candidate despite the wealth declaration. They're available within the government because we declare and submit, including last year, in November. So thank you very much, and it's such a privileged honor to be here.
Very well. We also thank you for availing yourself for this interview, and on behalf of the commissioners, we wish you well. We wish you success, and we always encourage our candidates to keep up their hope, serving Kenyans in whatever capacity that you are serving Kenyans. And you'll hear from us when we complete the process. You are now released. Have a good day.
Thank you, Honorable Chair.
You can take
Have
it
a good
with
day
you.
too.
Yes. You can even carry the bottle of water with you.
This one, thank you.